Justice Kavanaugh? Justice Barrett?
I just want to return to this control question in the colloquy that you had with Justice Alito. So the factors from our case law are the history, the way an informed observer would perceive it, and the control. And it doesn't seem to me that either history or how an informed observer would perceive it necessarily suss out this question of whether the government is using it as a cover. So you said in figuring out if the government is using this as a cover for censorship, we would be asking, is this more like a symposium, where a diversity of views on a particular topic are solicited and welcome? Is that a subset of the control factor? I mean, none of our cases that I can think of are really getting at that question of sussing out government just trying to put a stamp of approval on speech to weed out certain disfavored speeches, at least not Summum, Walker, and what was the other one? The
TAM.
License plate, TAM. Oh, yeah, the trademark. So how do you suss it out?
I think it's ultimately going to be really fact-bound. I guess I would point the court to Forbes, the Arkansas Educational Television Commission against Forbes. There, the court made clear that a public broadcaster who's exercising editorial control, a sort of curation of what programs to air, that's government speech. And the court said that expressly. Even though the programs are created by third parties, the editorial control was government speech, but a candidate debate in particular was a non-public forum in which viewpoint discrimination was prohibited. And that's the kind of analysis. Unfortunately, it is fact-bound. That has to be brought to bear in every case. But again, you have to look at the particular program. Imagine Summum, for example. Those three factors that you discussed were discussed in Summum and pointed toward government speech. But imagine if the city of Pleasant Grove also simultaneously reserved a corner of that same park for a Monument of the Week program. I think the court might have had in which all comers could come and put their monument up for a week as long as it satisfied certain size criteria, and then took it down and it was returned to them. I think the court might have had a different reaction to whether that piece of it was government speech, and that would be sort of regardless of whether a passerby would know that that corner was for the Monument of the Week or was for the permanent display.
So returning to Justice Kagan's hypothetical about how such a program might be structured, would Justice Kagan's envisioned program work if, to celebrate, all of the commitments and ideals of various civic organizations, the city of Boston sits down, asks what's going to be expressed, and says, yes, this is an idea that Boston can get behind, and a government official participates in the flag raising, participates in the ceremony, communicating that, yes, Boston is happy to celebrate and communicate Pride in Juneteenth, but no, Boston is not going to participate in a flag raising for the Proud Boys. Is that a way to structure Justice Kagan's program?
Absolutely. I think that would be government speech. With that level of control, that level of planning, and that initiation, I think that would be governmental speech.
So the difference is the government involvement. Like, it would be difficult to set up the parameters for, say, a limited public forum, as Justice Kagan was proposing. But if the government gets so involved in it that it's standing outside endorsing that speech, then it would be government speech.
I think that's right. The difference between a symposium and an open mic night.
Thank you, counsel. Mr. Hallward-Driemeier.
Mr. Chief Justice, it may please the court. The sole issue here is whether the city's decision to lower Boston's flag from the City Hall flagpole and raise another in its place is the city's own speech. If so, then, as Summum held, the city is free to select the views it wants to express. If, however, the flag raisings were private speech and the flagpole had become a public forum, then the city agrees that it cannot exclude petitioner's flag. Thus, whether the flag raisings were government or private speech is dispositive. The facts here are at least as supportive of the city as in Summum, and petitioner's counter-arguments rest upon a caricature of the actual events. First, Summum held that exercising final approval authority constituted effective control. Petitioner stipulated at PEDAP 149A that before, quote, final approval, any flag-raising Commissioner Rooney, quote, must review whether the city's decision to raise a flag is consistent with the city's message, unquote. As in Summum, there is no record of prior denials, but also no record of flag raisings inconsistent with the city's message. And unlike Walker, there are no purely private messages. Second, Summum looked to the general practice of governments erecting monuments. And similarly here, governments speak from government-owned flagpoles. That is what the observer would expect. Whereas Pleasant Grove made no express statement of its message, here the city has. It has a specific policy with respect to foreign flag raisings, and it has issued resolutions in connection with others. Third, as in Summum, it would defeat the flagpole's essential function as the city's bully pulpit to treat it as a public forum. The city cannot effectively use its flagpole to communicate its own message if it must remain neutral and also carry the opposite message. Private parties are free to wave their flags on City Hall Plaza or even raise a temporary flagpole there, but they cannot commandeer the city's flagpole to send a message the city does not endorse. I welcome the court's questions.